Fasten your seatbelts. We are beginning this hour here on Closing Arguments with breaking news. I'm Vinny Politan. Thanks for being with us. I'm sitting here right now. You know, I've been at CourtTV a long time. So long that murders that have happened and people who have been convicted of murders, all of a sudden, you're starting to hear that some of them are getting out. Well, believe it or not, as we sit here tonight, the Menendez brothers, Erik and Lyle, are one step closer to being set free. Did you hear me? The Menendez brothers, one step closer to being set free. And it's a big step because it is the prosecutor from the case. The prosecutor who's handling it now, not the prosecutor who handled it then, a man named George Gascan, who has a reputation in L.A. and San Francisco, where he used to be the DA, for setting criminals free. So when George Gascan speaks about a case and talks about we're going to take a look at it, oh, you are one step closer to being set free. That's the way it works. This is big news today. That's much closer to what they look like these days. Erik and Lyle, or is it Lyle and Erik? I don't know. I'll be honest with you, I don't know which one is which at this point. I haven't seen them in years. We've covered the story, obviously. But today, George Gascan out in Hollywood, and you know how this is playing, right? Like we had Rosie O'Donnell on this show, Kim Kardashian. Those folks are like pounding the drum saying, set them free, set them free. Then Netflix has this big series and people are looking at it. And now all of a sudden everyone, not everyone, but a lot of folks in Hollywood want the Menendez brothers set free. And George Gascan, who's the DA out in LA, his ears are wide open. Take a listen to what he said today.
First of all, I know that this is an area of tremendous interest nationally. We know, especially since the Netflix documentary came out, we're getting a lot of calls. Let me begin by saying, kind of walk you through a simple explanation of the legal issues here. There are two vehicles upon which people that have been convicted of a crime, well, there are many, but the two are a habeas, and the other one's a resentencing. They can ask for a review of their conviction. And their habeas, basically what someone that was convicted is asking a review of new evidence that had been made available. They had that evidence been available to the court and the jury at the time of the trial, perhaps the outcome may have been different. And then there's a second process, and it's called resentencing under California law, where a prosecutor can evaluate whether someone has been rehabilitated, and based on their actions and the fact that they're not involved in criminal activity inside the prison, that their sentence could be reevaluated. In this case, again, the Menendez brothers are asking for a review through both of those vehicles. We have not decided on the outcome. We are reviewing the information, but I think it's also important that we recognize that both men and women can be the victims of sexual assault. We started a consent campaign to be timed with the red zone. And for those of you who are not familiar with the red zone, is when new kids are going into college, and for the first time they're away from home, and we know that there's an increase in sexual assaults during that period of time. Now, most of the victims are usually young women, but there are men also that are victimized. And in our consent campaign, we made it very clear that only a clear and desirable yes means yes, and anything else is not consent. And I spoke very clearly, especially to young men, because most of the time are young women that are the victims of sexual assault, that they also have an obligation to understand that consent has to be very clear. But we also recognize that sometimes men and boys are the victims of sexual assault. We're seeing now the allegations that in the case of Sean Combs, according to the civil lawyers, about a half of the victims, and they could be way over 100, were men. And we have seen over and over again when both young boys and young girls are molested. So today, what I want to make very clear, we have not conceded one way or the other. We're not saying that there was anything wrong with the original trial. We have been given evidence. We have been given a photocopy of a letter that allegedly was sent by one of the brothers to another family member talking about him being the victim of molestation. We've also got evidence that was provided by the defense, by his lawyers, that one of the members of the Menudo van alleged that he was molested by the father. None of this information has been confirmed. We are not, at this point, ready to say that we either believe or do not believe that information. But we're here to tell you that we have a moral and an ethical obligation to review what is being presented to us and make a determination based on the resentencing side, whether they deserve to be resentenced, even though they were clearly the murderers, because they have been in prison for 35 years and they have paid back their dues to society, or whether a habeas is appropriate if there was evidence that was not presented to the court at that time, and had that evidence been presented, perhaps a jury would have come to a different conclusion. I don't think there is any question in this case that the boys or the men, young men, one was 19, the other one was 21 at the time, that they murdered their parents. I think that's factual, it's been established. I think the questions that are presented to us is two simple questions. One possibility, what is being alleged by his lawyers, not by us, that there was evidence that had that evidence been presented to the jury, the outcome of this case would have been different. And second, under California law, a path to resentencing where a prosecutor can evaluate whether someone has been rehabilitated, and if so, ask the court to determine whether the person should be resentenced. If they get resentenced, there are multiple things that could happen. They could walk out based on what the court decides, or they can have the sentence given a different shape, and perhaps they will stay on, but for a longer period, lesser period of time, or they can have a new trial, right? And those are all options, and we will evaluate all of it. We have a hearing coming up on November 29th, and until we get there, we're not sure yet which direction this will go.
Okay, I just want to remind everyone, it was a double murder. It wasn't just Jose, it was Kitty, the wife. And I know they're saying she's complicit in the molestation and all of that. But if Jose is murdered, shot and killed, is the threat gone? Is the threat gone? Yes, the threat is gone. I think that's still something that has to be discussed and talked about here, because it's double murder. Two victims, Kitty and Jose, not just the monster. And if he's that much of a monster, was Kitty a victim of Jose as well? But she got murdered also. I just want to keep perspective on it, right? So we don't conflate things, we don't leave facts out when evaluating all of this. And I know there's a big drumbeat. I'm telling you, listening to George Gascan, knowing his history, these guys are getting out. That's what I think tonight. That's what I'm thinking. They're getting out. They're getting out. Look him up. Research this prosecutor and see who he does not prosecute. See who he lets out. Why wouldn't he do this? I think it's going to happen. Let's bring in our think tank. Joining us tonight, criminal defense attorney Eka Mercy Also with us, former criminal defense attorney Kirk Nury, and the president of the West Coast Trial Lawyers, former federal prosecutor. He's out there in L.A. where all this is happening, Nima Rahmani. All right. Nima, I'm just going to go to Nima first just because he's in L.A., and I just want you to respond to what I just said. Do I have the right read, do you think, on this DA, that he is chomping at the bit and is sort of setting the table here, so he's going to set the boys free?
Oh, you're absolutely right, Vinny. I mean, I'm sitting here a mile from where George Gascan held that press conference, and you're really talking about a defense attorney in the prosecutor's office. So he's in the middle of a very contentious election, and let's be honest, this makes for good politics. The Netflix series Monsters has brought a lot of attention to Erik and Lyle and the sexual abuse that they suffered, and I think for political reasons, he's absolutely going to either not oppose the habeas petition or agree to the resentencing, and they're going to be free men. And it's just a matter of weeks where this is going to happen. The hearing's set for the end of November.
Okay. Eka Mercy, what do you think of this development? And this is a big development. This is a big development. Now everyone who is behind bars, including some woman from Arizona, probably wants a Netflix series right now.
Is it? I don't think it's that big of a development. They've been in prison for over 30 years.
35,
and,
yeah.
35 years. So as a criminal defense attorney, after they've had that much time under their belt, and the fact that that was their first crime, it's not out of the ordinary to ask, for reduction. So I actually think that press conference was like a master class in choosing to be effective versus being right. He was very clear that they committed the crime. He's merely asking for reduction based on the information. And I would like to make a note that, remember 35 years ago, no one talked about anything with regards to children, especially sexual molestation. And I mean, we had commercials that essentially had to remind parents where their children were at 10 o'clock. So it was a different time. Things like this were taboo, and the fact that they were boys at the time, as Attorney Gascan referred to, it was a different time. Half the stuff that they talk about now, they didn't talk about then. So I think that it is that they do have basis to try to get them to get time served.
All right, Kirk Nury, your thoughts on this? And I do believe at the time of the murders, neither boy was living at home. One was, I think, across the country, and the other had moved out and gotten an apartment in L.A. And I bring it back, like, they killed Kitty, too. They killed Mom, too. I know everyone's saying she's complicit in all this, but if you have a monster of an abuser in that home, I'm thinking Kitty may have been a victim as well. Kirk, what do you think?
Well, first of all, I think that lady in Arizona would certainly welcome you to her Netflix special, Vinny. No problem at all. But when we talk about that juxtaposition, I think you raise a good issue. But at the same time, let's talk about context here, and let's talk about what Eka said about reduction. Because I would argue that when a defendant isn't allowed to present a full defense, in this case, in the second trial, the trial they were convicted, they were in fact precluded from bringing in evidence of this sexual violation. And we also have to think about it not just in terms of killing, right? But we know the law accounts for different degrees of killing. We have first-degree murder and we have manslaughter, which I believe, maybe Nima can correct me if I'm wrong, is a 10-year sentence. So with that kind of in mind, and you think about the 35 years and what Eka mentioned about the time frame here, in terms of what this, the exclusion of this evidence, the dismissal of men as victims of sexual violence, all that leads to the idea that maybe had they been in front of a jury with this information of sexual abuse, not to mention the letter, but the other victims coming forward, you've got a good case to make for manslaughter, and maybe the jury would have saw it that way, or the judge would have been more responsive to those concerns in his sentencing. That's why I think this 35-year time frame means release is imminent, as you said.
Nima, in California, I know you're a former federal prosecutor, but in the state system, if you get convicted of murder, are you allowed to appeal it if something happened during the trial that you thought was wrong? Do they do that in California? And if so, did the Menendez brothers do that?
Yes, you can appeal, and the Menendez brothers did exhaust their appeals. So this is obviously a habeas petition. We know it's a collateral attack. Kirk is right. Eklund's also right. It was a 10-year maximum sentence for voluntary manslaughter. And just so everyone at home is watching, right, this is an imperfect self-defense case. No one, I think, genuinely believes that, Lyle and Erik were in imminent risk of death or serious bodily injury when they shot their parents in the back of the head while they're watching TV. So
and eating ice cream.
Self-defense. Yes. Imperfect self-defense in states that allow it, like California. If you genuinely but unreasonably believe that you're at risk of death or serious bodily injury, and the argument here is that exposing Jose Menendez, the brothers believed that he would come after them and kill them. That's the argument, and really a lot of that was precluded at the second trial. I don't think that this necessarily fits within this 4 square corners of that argument, but really, what's the fair and just result here? If someone was indeed molested by their father and their mother was complicit in it, even though it was first-degree murder, which in California requires a mandatory sentence of life without the possibility of parole. And let's not forget, the death penalty was on the table for these two at the time. Obviously, there's a moratorium here in California. Their lives were saved. I think the fair and just result after 35 years, if they were indeed suffered this abuse, and I believe that they were, is for them to be released. And that's coming from a former prosecutor, even though, again, doesn't necessarily fit within the 4 corners of the law, especially, Vinny, like you said, as it applies to their mom, Kitty.
Eklund, I know you want to jump in. Do you want to hear Lyle's confession tape first, talking about his mother? Let's take a listen to that, and then you'll wrap this whole thing up. Here's Lyle's confession tape. Lyle says he thought of his mother's murder like a suicide. Take a listen.
And I still think Mom's was a suicide because, I feel that in her letters to Erik and I, she gave me the permission, and it's burdensome to continually be handed to me. Erik handed me it to talk to Mom. Dad handed a lot of things to me. She had given me permission to please carry out her suicide, and that it was obvious that she had decided in her mind she wants to die. She can't do it, and she doesn't want to talk about it. And there's nothing that I can do to help her. There's nothing anyone else can do, and she very much doesn't want anyone else to know that what Erik and I did took her courage beyond belief, beyond strength. There was no way I was going to make a decision to kill my mother without Erik's consent. I didn't even want to influence him in that issue. I just let him sleep on it in a couple of days. Because I'm in a very good position to influence Erik on a lot of things. Because he knows that I care, and a whole number of issues that I can talk eloquently on whatever. But when it came to that issue, I wanted nothing to do with it. It had to be his own personal issue. He felt the same way I did about killing Mom. I feel angry toward my relative. Why didn't you do something when you knew what was going on and I didn't? And when I found out, I did something about it. I did what I thought my mother would want me to do, which is please kill me. And I can't, and I just couldn't just kill my mom. That would be ridiculous. I wanted to get rid of the source, but I couldn't live with that. Nobody could.
Okay, I listened to that, and to me, that's just incredibly cold. But go ahead.
Well, I have 2 points. Number one, with experts on child sexual abuse, they usually say that the abusers don't pick the kid, they pick the parent. So they pick the mom for their complacency, like it's the mom that they focus on. And second, I think we're forgetting another defense that they had, which is Mr. Menendez was worth $14 million in 1994. Based on inflation, we're looking at $30 million in current time. Not only that, he had connections. He had connections. He had the money. He made the threats. So if you're looking at from 19 years, this person has made threats, and is because of the threats you have been enduring the abuse, I think that if you come to a head, that can still be an active threat. $14 million is nothing to sniff at.
Oh, I know. He's a powerful man, and allegations that he did it to one of the members of Menudo. I mean, this is all bad stuff. I'm just wondering, why Kitty? Why Kitty? All right.